everyone, this is Charu, legal intern at LEXIS and Company. Today's video is about attempt to murder and culpable homicide. Culpable homicide and murder are defined in section 299 and section 300 of the Indian Penal Code respectively. There is a very thin line difference between the two offences. Furthermore, an attempt to commit the same is also an offence under the Indian Penal Code. Their attempts are respectively defined under section 207 and 208 of the Indian Penal Code. Under both the section, a lot of weightage has been given to the intention and knowledge to commit such an offence, and both the section requires a proper analysis while convicting any person under this. Let's first know the meaning of attempt. Section 511 of the Indian Penal Code talks about the punishments relating to an attempt to commit any offence, but it does not define the term attempt. If the crime is impossible to commit, then it will not be considered as an offence. This is with the exception that instigating or manipulating someone in order to make him commit the crime is not an offence. It is an offence under the attempt to commit a crime. Now there are 4 stages to commit a crime. If a person commits a crime voluntarily or even if he prepares to commit a crime, the following 4 stages of a crime should be present. Stage 1 is related to intention. Intention to commit a crime is a mental stage. It is the willingness of a person to commit an act. The law does not consider the importance of intention, like mere intention to commit an offence without any physical act done does not constitute a crime. The guilty mind or evil intent should be visible. The stage 2 is preparation. This stage involves the arrangement to execute a crime. One should keep in mind that at this stage, no offence has been committed yet. As preparation for any purpose is not a crime. But certain acts under the Indian Penal Code can be prosecuted at this stage. For example, preparation to wage war against the state and preparation to commit dacoity are punishable at this stage. An illustration for this stage can be like if A purchases a pistol in order to kill his enemy S and keeps it in his pocket and does nothing. This is not a crime. This is just a preparation to commit the crime. Stage 3 is related to attempt. The attempt of crime occurs while preparing for it is done. The attempt is a direct action towards the committing of an offence. Most of the sections of Indian Penal Code makes the attempt of any crime a punishable offence. The stage 4 is completion or accomplishment. To make it a complete offence or a complete crime, the completion of a crime is very important. If a person attempts to commit a crime and eventually succeeds in it, then he will be held guilty. Through an illustration, we will summarize the 4 stages. Like for stage 1, that is intention, X makes a plan to kill Y. Stage 2, that is preparation, X buys a pistol to kill him. Stage 3, which is attempt, X points the pistol at Y and shoots him. Stage 4, completion, is when Y is killed because of the gunshot, then X will be held liable for murder. But if Y is only injured, then X will be held guilty of attempt to commit murder. The scope of section 307 and section 308 of IPC. Section 307 of Indian Penal Code addresses an attempt to commit murder. Whoever does the act with guilty intention or knowledge, and the person who knows that the act is likely to cause death or has the knowledge that by the act or injury the result will be death, only then he would be held guilty of murder. For example, let's assume Mr. T is planning to murder Mr. P. He collects some toxic chemicals with an intention to mix it in Mr. P's food. Until Mr. T has served the food, he hasn't committed any offence. But if he places the poisoned food on Mr. P's table or it gives to Mr. P's servant, then Mr. T has committed an offence to commit murder. Let us see a few essentials of this offence. The first essential is that the nature of act is done. The intention or knowledge of committing an offence. The performing or execution of the offence towards it. The act in an ordinary course of nature will cause death. The two most important ingredients are knowledge and intention to commit an offence. To decide upon any act done under section 307, the three essentials are nature of an act done, intention or knowledge of committing an offence, and performing or executing of an offence towards it. The objective of this section is that the intention or knowledge of the accused is significant. To constitute an offence of murder, intention or knowledge is necessary. Without any intention or knowledge, it is difficult to determine whether there is an attempt to murder. Is an attempt to commit murder and culpable homicides a bailable and cognizable offence? Now let's answer this question. Offences in which the permission from the court to release the arrested person is not required. The arrested person, by fulfilling the necessary requirements, can be released and the police cannot refuse the person. Cognizable offences is when offence is in which the police has the authority to arrest any person without any warrant and also has the authority to start an investigation with or without any permission of the magistrate by filing FIR. Attempt to commit murder and culpable homicide are both non-bailable and cognizable offences. So that's it for today's topic, guys. Don't forget to like this video, comment your thoughts and feedbacks, and subscribe to LEXCLIQ for more legal stuff.